glad you are back open again. No, but we sure did have a big slowdown, that's for sure. And so I think it's kind of rocked our world. It's totally changed the way we've been doing business. And I know that I think some of us have been using different mechanisms. Some of us have been using Zoom. Some of us have been using Skype. I think there's another one. I don't know the name of it. But we have all become way more proficient in Zooming than we ever thought we could imagine. And so let me just say a couple of things about, I guess, criminal court. That has totally changed right now. The majority of criminal court was proceeding by Zoom. We're doing everyone that's in custody by Zoom. I think that part of the processes that we have already been implementing, I think we will carry into the future. For instance, I think that we will be Zooming with other counties when our prisoners are located there, with prisons around the state, to maybe avoid having to transport individuals. And that's been going really good. For our out of custody people, I know that we've been doing kind of what I refer to as our hybrid, which is we now have people that are coming into court. We now have people that are Zooming by their telephones, which is just great. And then I know Judge Scorsoni was very helpful in working with our DPA about getting some other locations for individuals that maybe didn't have the telephone capacity, could actually go to get a Wi-Fi and have a Zoom connection. Judge Scorsoni, you want to maybe address that?
Well, the two places that are available for indigents or folks who don't have Zoom capabilities at home would be the Hope Center or the Catholic Charities. They both are willing to make their computers available for Zoom access to any criminal defendant or even civil cases that they need to Zoom for.
Great, thank you. And I think that's really been working great. I don't think we've had anybody that I know of that has said, we want to Zoom, but we don't know how to, or we don't have access to. So I would go 100% for anybody that's wanting to do that. And the lawyers have been great in contacting their clients and getting that set up. As everybody knows, our criminal trials have been pushed back. That's a problem, but it's one we're trying to address as best we can. As of right now, they have said August 1 will be the date that we can start having trials again. I can tell you all that as a court, we're very concerned about our jurors and how it is that we're going to be able to select a jury. So right now, we're very aware of our 33% capacity. We're aware of 6 foot social distancing. And if we didn't have to select a jury, we'd be ready to go with jury trials. But it's the jury selection process that is going to be a challenge for us. I know that we have discussed the possibilities of maybe, seating 2 panels, 3 panels, dividing them up somehow. And, lawyers keep asking me, it's like, what do you think we'll have trials in August? And my answer to that is, I don't know. Counsel, I'm asking my fellow judges if they want to buzz in and see if they have any other thoughts about that.
I had a couple of trials. I had some trials scheduled in August, and having spoken with some of the lawyers over the last few days, I think the lawyers are very hesitant to have trials in August because no one knows what it's like to try a case before a jury who's, in the best of worlds, the jury doesn't always want to be there. And in this world, they have some real concerns. Some people have real concerns about being there and health concerns and are distracted. And so I think there's some sentiment out there is we want to have our trials during a more normal period and not right off the bat during this, where there are so many unknowns about how it's going to affect things.
And to add to that, I did talk to Judge Reeves the other day because the federal courts have had jury trials, and he said that it is extremely difficult and they're required to wear masks, and it's hard for the lawyers to be heard or understood by the jury. So there are little nuances that maybe we're not even thinking of that if we attempted to have a trial might affect even the outcome or how the cases are able to be presented. So he said, well, they're doing it. There have been major issues, and those are the kinds of things that I think Judge Van Meter's right. It would be interesting to hear how the lawyers feel about, do they want to try a case in front of a jury with a mask on, or if they'd rather wait.
Well, I know early on, Daniel Whitley, who used to be with DPA, who is now out on his own, had expressed the concerns about minority representation for our jury trials. And I think, you know, when we think about how many people have been unemployed, how childcare is just now becoming available again, even at reduced numbers, you know, if that's going to impact minority representation, because if we have folks that do come for jury duty and they say, Judge, I haven't worked for 4 months. I can't, you know, serve for a month as a juror. I think we're all going to be sympathetic and try to work with them. And I don't know what the numbers are going to be, but clearly it's going to be something we're all going to have to be aware of. Regarding criminal stuff as well, Dana Carter and her staff have been fabulous in trying to get grand jurors selected and randomly selected. So we did not call in entire panels because we didn't have space to do an orientation for a group of 250 or 300 people. And so instead, so that we could have a grand jury that was up and coming, and we have made arrangements now that they're in the multi-purpose room so they can socially distance. They're wearing masks, but she randomly was selecting from the pool, and then they were calling individuals to say, you have been selected as a grand juror. Here's what's going to be expected of you. Are you willing to serve? And it was amazing the number of people that said, yes, we can serve. Yes, we're aware that, you know, we have to wear a mask and it's not going to be as comfortable. But what we have done is that we ended up doing 2 panels for the month, so that each panel did 6 days, Monday, Tuesday, Wednesday, Monday, Tuesday, Wednesday. And the Commonwealth started with the individuals that were in custody because we had already exceeded what originally we have our 60-day rule to have them indicted. By Supreme Court order that has been lifted, but they are concentrating on the in custody individuals first. And so we're beginning to see a lot more activity in our regular criminal motion hours as well.
We have a question.
Okay.
Jay Prather asks, has there been any consideration to expanded jury questionnaires that would allow the jury panel to be winnowed down? For example, obvious schedule conflicts or unopposed strikes for cause removed before the jurors come to the courthouse.
Does anybody want to take that one particularly?
Well, Judge, I can say that the juror questionnaire comes from the Administrative Office of the Courts, approved by the Kentucky Supreme Court, and there hasn't been no changes on the qualification form as such. We do include a frequently asked questions for the jurors when we send out the summons. That is something we could do locally, but as far as the change of the actual form, that will have to be done and approved by the Kentucky Supreme Court.
And I think Mr. Prather may be talking about the lawyers, you know, along with the judge oversight, coming up with a questionnaire for the case, so that some of those initial voir dire questions are done by this questionnaire that's filled out and then mailed in. And so maybe you're not starting 70 people calling in, maybe you're starting with 50 people you're calling in. And so I think Judge Travis and I may have discussed that early on, just the possibility of how getting our heads around how we can get back to voir dire. And so I think that's certainly something that could be discussed when we get back online. Is there anything that can be done in advance of calling the jurors in, because that's Hans Poppy circulated to all of us. This American Board of Trial Advocates has circulated some guidance for conducting jury trials. And one of the things that they recommend is really only calling jurors in when you need them, and really only calling in as many as you need. So this would theoretically be one way that you could weed out some obvious strikes, so that you're calling less people in. So I think it's a good idea and definitely worth talking about.
Okay, so since we kind of went into civil, civil motion hours, and God, please correct me if I'm saying this incorrectly for all of us, but I think that either motions are being directly scheduled with the judge's office, or they're being noticed for our regular motion hours. And then more often than not, our staff is contacting the lawyers to set a separate Zoom hearing time. Does that sound like what we're doing across the board?
That's
Yes.
what the fourth edition is doing, yes.
Judge Travis?
Yes, that's what I've been trying to do.
Okay. And so since we are doing that, we are creating a huge number of these little miniature hearings. And so any chance that you get to tell us in advance, and I don't know if it's something that lawyers would feel comfortable putting on their papers, but like the opposing party's email and their own emails, because obviously that's the way all of our Zoom hearings are being scheduled. That would be just one less step. The lawyers may also be asked for them to contact the other 3 lawyers to say, hey, let me give you 4 dates and see if y'all can come up with one in a time that would work for everybody. So we continue to thank the lawyers for their cooperation and patience in trying to get all of that scheduled. Now, Judge Van Meter, I think that you had gotten some numbers together for us about how the virus has impacted what we're doing around here.
Sure. Yeah, so it's obviously impacted on us on this side, because all the in-person dockets were shut down by that Supreme Court order starting on March 16th. But those cases go on, and I was curious to see what was happening on the other side, on the lawyer side, because we were seeing some motions where perhaps a legal department and a client had been furloughed, and request to stay the case, for example, or some disputes about should depositions go forward by Zoom, or should the parties wait until the depositions can happen in person, and there's not always agreement on those things. And so I know there's been changes, in the practice of cases because of this also. So our administrative office of the courts tracks all the filings, and so I asked them to look at how the filings have been affected by the COVID-19. So if we look back at 2019, in April, there were 233 civil cases filed. And in May of 2019, there were 271 cases. And so that's roughly the average if you look over the year. So that's about 500 for those 2 months. During the same period this year, we were under 300 cases, so 294. So new civil filings were down 42% in Fayette County. And it was the same across the state. The state was down about 45% for new civil filings. And of course, there's no reason why new cases couldn't be filed. You could e-file. There's no barrier to that, but obviously other things were happening that were slowing those civil cases down. Either lawyers' offices were closed, or clients weren't able to get to those offices to have those initial conversations to get the case going, but they were down about 42%. On the criminal side, of course, since we didn't have a grand jury for April or May, they were way down. In that 2-month period in 2019 for April and May, there were 314 new circuit criminal cases created. And then for that 2-month period this year, only 22. So criminal cases were down 93%, which is, of course, what you would expect without a grand jury.
Okay, thank you. Well, sometimes when there's a change, we get a little push in a direction. And one of the nice pushes, I think, has been electronic filing. And so I think that as a bench, I think that we have done a really good job of reacting, and we are doing a lot more electronic signatures. I think that more lawyers are doing electronic filing. We still have district court as the primary drop area for paper documents. So please, everybody, continue to take things over there. Per Supreme Court order, the clerk's office is still working at on a 50-50 rotation schedule, which means 50% of their staff works 1 week. The next week, the other 50% work. I think they've been picking up some extra days, maybe on the weekends. I'm not exactly sure how that's going, but I know they've been trying to address a bit of a backlog because of their reduced capacity. But that's because in the event that somebody becomes sick with the virus, it's possible that they could have been in direct contact with the staff that was there that day or those few days. And so if that happens, potentially 1/2 of the clerk's office could be quarantined for 2 weeks. And if it was the entire office, that could shut us down. So please continue to be patient. I think that most of us, if not all of us, are still accepting emails. If there's an email copy of a document, if you send it to the other side and us, you don't have to worry about it being ex parte communications. You can also send it to our staff attorneys, our secretaries. And I just know that, for instance, today, something had been filed electronically on Friday, and it didn't get processed until end of the day yesterday, but it was for a hearing this morning at 10 o'clock. So I was just getting it this morning and trying to get all that. And I just reminded the lawyers, feel free to email me copies of documents that are being filed.
Yeah, can we emphasize that a lot? Courtesy copies to the judges, please. You can fax them, email them, hand deliver them. But if you don't send me get me a courtesy copy before motion hour, chances are I won't get a chance to read your motion. So please do that. And along that line, as Judge Bunnell indicated, the clerk's office is operating 50-50 operation there. So oftentimes we'll sign an order and take it down there, but it doesn't get processed for a while. And, don't take it personally. It's not, the judge's office is not trying to do anything to you. The only thing we can do is sign the order and take it downstairs, but then it's going to be up to the clerk's office to process that. And there has been quite a bit of delay. Apologize for that, but it's not in our purview to cure that. It's down in the clerk's office.
Yeah, and if there is something that is of a high priority nature, be sure to let us know. So, we can put that to the clerk's attention. Please process ASAP, and they'll do it.
Yeah. In that note, I would agree with the judges. Please send us courtesy copies. Because of that delay, there are times we don't get it, and we're thrilled to have the courtesy copy so we can address it right away. I will tell you, because I understand that the clerks are really stressed due to the being only 50%, trying to get dockets taken care of. So when I sign an order, I will send all the lawyers a courtesy copy by email. But of course, it's not stamped by the clerk, but at least you know what I've done. So I've been doing that probably since, I guess, probably since March or April. And so I'll continue, the 4th Division will continue to do that so that you'll at least know it's been addressed and signed. You just won't have the stamped filed copy.
I think it might help the civil lawyers to know when we're talking about courtesy copies, even though the filing deadline for Friday motion hour is Monday, that civil docket is not processed and brought to us until Wednesday afternoon. And that's under normal circumstances. That's not even under, sometimes in a 50-50 situation, it could be Thursday, but it's usually not until Wednesday afternoon. So it is really helpful if you have something substantive or it's going to take a little bit more time to send that over on Monday when you file it, or even if you filed the week before, because I think a lot of lawyers think, well, the deadline's Monday, so they know I've filed it, which is not always the case.
We
Now,
do
Judge,
have a couple of questions. I'm sorry. Okay. The first question is, with respect to civil or criminal trials, have we given any thought to contingencies if someone was to test positive during the course of trial? If so, what would they be?
it seems like the recommendations that we've been getting, we've just been seeing coming across the emails are, seating more alternate jurors, but that's not going to get it done. I mean, if they're all sitting there next to each other and they've all been back in the jury room, then, and if they actually test, positive, right now we're knowing that if they're symptomatic or asymptomatic, they're probably asking us to quarantine. So, do you delay the trial then for 2 weeks? I don't know. I've told my fellow judges that I have said the phrase, I don't know, more in the last 4 months than I've probably said in my entire life. And it's still a constant work in progress, and I apologize for that.
We saw a little bit of that. We did, as Judge Bunnell said, call in our first grand jury, the hard work of Ms. Carter. And we have 2 grand jury panels. I'm the grand jury judge this month. Our first meeting was on a Monday. And on Monday night, one of the grand jurors called to say that her ex-husband, who has joint custody with her son, had just tested positive for COVID-19. So the issue was we had to, and we did tell all of the grand jurors the situation. And the consensus was she and her son got tested. If they had come back positive, then all of the grand jurors would have to be quarantined for 14 days. And the grand jurors made it clear that if she came back positive, that was their intent, and certainly none of them would be coming back. So we've already had a little bit of that. And I think when we're faced with putting people in those type of situations, that their health is going to have to come first. And right now, it's my understanding, and the other judges can correct me, but the last time I looked, because I read the CDC again, is if somebody tests positive and you're exposed, it's a 14-day quarantine.
So then later we found out she tested negative, the child tested negative.
And everybody came back.
And everybody came back. And I'm telling you all, our grand jurors are just troopers. I'm real proud that they had such a desire to serve and understood that we really need them. So that was great. So Ms. Arnold, I think you had another question.
I do. If we need to email pleadings to the staff attorney or secretary or whoever in the judge's office, can the judges please make those email addresses publicly available or accessible through some forum?
Sure.
I think that's a good idea.
Yes.
Yeah.
We'll get that
Most of the
information to you,
attorneys
Ms.
call
Arnold.
the judge's office. I mean, the
Exactly
attorneys
right.
generally call the judge's office and find out who is the staff attorney this year, what's the email, or the secretaries. But yeah, I mean, we could, the Bar Association could do that, but it's constantly changing because staff attorneys, change all the time. Yeah.
We could put together a quick list with a phone number, the division.
And there is a way, some people who e-file and Daniel Whitley is good at this, if you know Daniel. So when he e-files, he does something to where I get an email notifying me that he has e-filed, and it comes right to my email, and I can click on that link and print the motion and see what it is. Other attorneys who e-file don't do what he's doing, and it doesn't come to me. So there's not, there is a way to send a courtesy copy electronically. And Judge Bunnell is she might know, she's the master on e-filing, but I know that some attorneys are able to do that electronically.
It says here that somebody said in the courtesy copy of the e-file, you would type the judge's email address. That must be how we're getting it. And I know the Commonwealth attorneys do it as well. That's from somebody who's—
I think it's from Andrea Williams at the Commonwealth.
Yeah.
Yeah.
Yes. And the Commonwealth attorneys always do it. Or not always, but most of them do. And I'll get their courtesy copy, the notice, and then you can just print it right from your desk.
I don't have any more questions right now, but I have a list of questions if you would like to start with those.
Okay.
Do you believe Zoom hearings are as effective as in-person hearings?
I think it depends on the lawyers and the case. Some are, absolutely, in my opinion.
Ms. Corsoni?
Well, not if you're going to have witnesses, and I mean, the whole point about, the discussion about wearing masks, in a courtroom, you want to see the facial expression. And the same thing with Zoom. I don't think you can get, as clear a facial expression as you can in person. So no, I think it's not ideal. I think it's acceptable. And the Supreme Court certainly tells us to use it. But no, I don't think it's ideal, and it's not as good as being in person.
Yeah.
Well, I've had, during the quarantine, of course, our civil hearing or criminal hearings were proceeding by Zoom. And then we were pulling all the civil motions that have been made and contacting those lawyers and trying to get as many scheduled by Zoom as we could. And I went through my calendar and counted up. We're able to do about 50 during that shutdown period of civil and criminal hearings by Zoom. And for most things, I think it works just fine. I had some evidentiary hearings by Zoom, and we used the waiting room. So we would, all the attorneys and the parties and the witnesses were there for the initial, the initial conference. And then we put the witnesses in the waiting room, and then we brought them in one at a time to testify. And it was fine. I agree with Judge Corsoni. It's better to be in person, but if you can't be in person, I think it's better to keep moving. And so we've tried to continue moving with those Zoom hearings. I like Zoom. I had a pretrial conference today by Zoom, and I don't see any reason why we can't continue to do pretrial conferences by Zoom and save people that trip to the courthouse, particularly if you're an out-of-town attorney, because we're usually not on the record. If it's just a kind of a standard pretrial conference where we're going to set dates, we would typically do that just in the office anyway, and we can do that by Zoom just as effectively with a small group, kind of discussing the status of the case. And for, discovery disputes and venue change and lots of these kinds of smaller motions that are on Fridays, I think it's fine. If I was a lawyer and I had a big case that was dispositive or that was going to have a lot of exhibits, then I can see wanting to do that in person if that's the option going forward. But I like Zoom. And now that we're set up for Zoom, I personally don't mind continuing the practice, even when the COVID, cloud goes away.
In fact, I haven't liked it, and I do most of my pre-trials by Zoom. I have a receivership case, and one of the lawyers two of the lawyers are in California and one's in New York, as well as several here. And we've been able to have weekly hearings on issues, and we've been able to do them because of Zoom. And so I think there are, even when this passes, and this too will pass, at least that's what I keep telling myself, this too will pass. Even when this passes, I think there'll be times where Zoom will be more effective, because as Judge Van Meter says, people won't have to get on a plane and fly here, and you can actually have more things handled more effectively and more often than trying to get people from out of state.
And I've had hearings where the clients are out of state and the clients Zoom in and watch the hearing. And if we weren't in this pandemic, they probably wouldn't be watching the hearing. It probably wouldn't be worth their time and money to get on a plane and come here and watch, but it's actually allowing more participation, because it's very easy for the client or the party to get on from their office or their home, if they live in another state particularly, and participate in their own case, which I think is a good thing. You know, our court systems we're open to the public. So I think it's a good thing for people to be able to participate in their own hearing.
Judge Travis?
I have just a comment about that. I think at the end of the day, the client who's paying the bill for the attorney is going to be another factor in saying this works better for us as well, in terms of keeping our expenses down, our legal expenses down. So that's another reason why I think this is something that we've had to do, that we're probably going to be adopting and using a lot more of going forward. I will say one thing. I heard a funny story the other day about a Zoom proceeding in which one of the attorneys, a participant, apparently wasn't very happy with the judge's decision, but forgot to mute his comments following the decision being rendered. So for those practicing out there, make sure that if you got some less than complimentary things to say about the judge, hit the mute button, okay?
Was that in the Fayette Circuit Court, Judge Travis?
No, that happened somewhere else.
Okay.
That wouldn't happen here, of course, right?
I will say that we have some new technology, and right now it is in my courtroom and Judge Van Meter's courtroom, but it's coming to the other judge's courtroom, and we have a new large monitor that also has a camera. And so we are able to turn that monitor and face it into the courtroom. And so then we invite the clerk to join the Zoom conference by email. And when he or she logs on, that triggers that big monitor. And so the way we're looking at each other right now, we all have those little boxes. There's another box then that has just what is showing in the courtroom. And so the Zoom meeting is projected up onto our large screen in the courtroom. This new monitor then is showing what's happening in the courtroom. And so what we're seeing, especially in our criminal cases, we might have a defendant that is showing up in person, and maybe their lawyer is concerned maybe with some health issues, and they're not wanting to come into the courtrooms. And we are all trying to work with everybody so that everybody feels comfortable either proceeding by Zoom or in person. But the person that's standing in the courtroom can look up at the big screen, see their lawyer. Their lawyer then on Zoom can be looking at his or her screen at home and see the person in the courtroom. And that is working marvelously. My civil hearing this morning was that kind of a hybrid. I had 2 lawyers that were participating in the hearing. And so the monitor was pointing at the 2 of them. I had 1 other lawyer in the courtroom to observe. And then I think I had 12 lawyers observing by Zoom. And so it really is an efficient way of doing things. So, and it's all being recorded directly into the court system. and we haven't had any problems, knock on wood, in terms of the record being good. Now, we're still having some issues on occasion with our Wi-Fi not connecting or computers having, I don't know, stomach aches or something. But then we panic, and then Dana fixes it and calls tech, and they come running, and we all scream the sky is falling. But overall, it's working.
Yeah, it's worked for me too. So last Friday on the criminal docket and the civil docket, I had hearings where on the same case, a lawyer would be in the courtroom and a lawyer would be on the screen, and they could see and hear each other. Now, with masks, the hearing is more difficult. So it's workable, but if you have a serious hearing where you're going to be going a while, I'm not sure that's ideal, but it works. It works for a Friday docket. And that's what I was most worried about, is how do we allow people to participate by Zoom, but also account for, these cases, particularly foreclosure cases, where you have a lot of pro se people, a lot of pro se parties who may not be able to call the judge's office and get the Zoom invite, or may not have the technology to Zoom. So I wanted to make sure the door was open so that person could come in if they wanted to, but then the lawyer is on the screen and that they can still see and hear each other. So that is working. And I think we're the only two set up for that now, but hopefully more is coming to allow everybody to be able to do that.
So for you two that have that current system, I think the challenge has been picking up the sound, right, of the other individual that's in the courtroom who isn't a participant in the Zoom proceeding. And there's been a little feedback in other ways we've tried to do that, but you two are saying you think you've solved that problem with this big screen. Is that right?
The screen solves the problem. There's no feedback because that computer is not logged on with sound. The sound is running through our courtroom system.
Okay.
Yeah, it's just a video feed.
Ms. Arnold, I think you got some questions now.
I do have some questions. I'm going to start at the bottom. As someone was asking about the Wi-Fi account password at the courthouse, the FCBA password, and I'm looking for it to make sure I'm telling you correctly, is the word Atticus, ATT exclamation point CUS 123. And that's for members of our association. And I will publish it in here, and I will put it on the chat once I make sure that that is exactly what it is, because that A might be capitalized. I don't know. I'm looking to make sure. The first question we have is, assuming there is a backlog of criminal trials, will those take precedence / priority over civil jury trials?
Well,
Okay,
we certainly have many civil or criminal trials that were scheduled to go in end of March, April, May, June, and July that didn't. Some of those cases have resolved, and there have been pleas in some of those cases, but many of those will have to be rescheduled. And I was looking for I think the Supreme Court order says that we are to give priority to those criminal cases, particularly if they're in custody.
Yeah, I think that, and that's consistent, I think, just with the law itself.
Mm-hmm.
If a criminal defendant has invoked their right to a speedy trial, then I think that we are obligated also to try to oblige. Those that are out of custody, you don't get a lot of motions for speedy trials. And so I think that when we look at the folks that are in custody, I think we're all going to be trying to set those trials as soon as we can and trying to take into consideration our jurors. Okay, Sarah?
Okay, are we ready for the next question? Okay. Have any of you considered mandating mediation 30+ days before civil jury trials begin in order to promote settlement and clear the backlog of trials. I have seen this done in other jurisdictions.
Well, just in terms of 7th Division, I always require mediation, formal mediation, before I give a trial date. So only if it's unsuccessful, then will I give a firm trial date. Generally, I don't require the parties to do another mediation right before trial. Rarely I've done it, but and not as a rule. I don't know about the wisdom of doing a second mediation 30 days before trial. That's my take.
And I usually, in my pretrial orders, I always require, I'll go ahead and give a trial date in the pretrial order, but I always require that it is mediated before trial.
As a lawyer, I never understood why I had to go to mediation before I could get a trial date. That would frustrate me when there was that kind of hard rule. But now that I have to keep a trial calendar, I get it. I understand it, because it's so difficult when to get those 3 or 4 days in a row and then block them off, and they take up this space, and then you find out the Friday before the Monday that it's settled. And that's great that there's a resolution, but then here's all this time that really could go to some other things. So I understand the reason for the rule now. I don't have a hard and fast rule. I kind of just sort of see what the case, what is the case, and what seems to make sense for that case. Generally, I think mediation is a good thing. Generally, I think all cases should go to mediation. There is that case from time to time where the defendant just says, I've seen their demand. There's no way in this world I'm ever going to meet that demand. Or there's no way I'm ever going to offer anything more than X because of the way I value it. And there are those cases where, it's just something that maybe that needs to be tried. So, I am open to the case here and there that doesn't make sense for mediation, but generally I think it's a good exercise to engage in and resolves most cases. Although I'll say in my first 18 months or so that we were having trials, I had more civil trials than criminal trials, which surprised me.
Mr. Travis?
I may comment. My attitude about this subject is very much like yours until I got on the bench. And then as long as I've been here, I've kind of come full circle on that opinion about mediation before trial. And I've gotten it basically into the practice of kind of like you, sizing up the particular case to see whether or not that should be a requirement. More often than not, it is. Really, probably the only exception to that may be the cases where they might be a little bit more complex and difficult, and the participants may have a number of expert witnesses that they know they've got to get on a schedule, certain, even if it's a year out, if they're going to call that witness live or expect them to testify in a trial such as a medical malpractice case. But more often than not, I have gotten into the practice of requiring the parties to mediate.
Yeah, and I think timing is everything. And so I think we all, look to our lawyers and go, when's the best time for this to go to mediation? I'm not sure about trying to order another one at 30 days prior to the trial. But I do think mediation is a good way to resolve a lot of the conflicts.
And definitely what you don't want to do is show up the morning of trial and announce you have a settlement. And then that is the worst, because then you've got 70 jurors out in the hallway who've not gone to their job, who've made childcare arrangements, organized their life to be here. And then we tell them that we've wasted their time. And then Ms. Carter has to send them a check. So, that call goes out Sunday afternoon. So if you resolve a case after Friday over the weekend, always figure out how to call and get our cell phone before the weekend, because if you think it's going to resolve it is so, so helpful to know before we tell the jurors to come.
Yeah. And also, I think mediation is one of those things where Zoom, I don't think should play a part. Okay. I think mediation is very important as a ritual where you actually have to be present someplace. You know, you've got to get out of your comfortable home or office and actually go someplace and meet with a mediator and go through the ritual of presenting your arguments and having somebody go back and forth between the two groups and try to reach a middle ground. You know, the same reason you shouldn't have somebody with authority that could just phone in mediation. They've got to be there with authority, you know, the ability to write the check. And I think the ritual is very important in mediation. And that's why I would not, you know, I wouldn't allow parties to appear through Zoom for mediation. I think they got to be there.
And our local rules address that. I was trying to see if I can find the rule, but our local rules require in-person attendance.
Yes.
By the decision maker. And so if there's going to be a departure from that, both parties have to be in agreement, because otherwise the rule requires, let's see, the party, or on behalf of a public or corporate entity, a representative other than the attorney having full authority to settle must be there in person.
Yeah, and I would never let the parties waive that.
The following, unless stipulated by the parties, also a representative of the insurance carrier for an insured party who has full authority to settle without further consultation is supposed to be physically present there under our local rules.
We had an attendee say, but many companies have issued policies that their claims people cannot travel right now. This is with respect to mediation.
Yeah.
Right.
They can Zoom.
I will say anecdotally from some of the practitioners out there that I've heard from, I have been quite surprised to hear that the mediation has been ongoing and been still quite successful despite perhaps not being able to do everything in person, which is more ideal, obviously. But it seems like it's still functioning out there, and to my surprise, quite effectively.
I'd like to do a commercial.
Okay.
Can I do a commercial?
Yes, it's your show.
Yeah.
Okay. So the Master Commissioner is evolving with the change of times also. So we can't be having the multipurpose room full of people for auctions. So he is inquiring into video, online auctions. And so for those of you all that participate in that type of business, be sure and be in contact with the Master Commissioner's office to see how that's all being set up and make sure you're getting proper notes and everything. So I think that's going to be an interesting evolvement of the system.
Great. We have another question. Maybe getting a bit ahead of ourselves, but do you envision that we will be able to request a Zoom hearing in the notice portion of the motion?
Well, as I mentioned this earlier, I like Zoom hearings, and I am definitely open to continuing them even after the COVID passes. That particularly if you have an attorney who's out of town. I mean, I remember driving 3 hours to have a 15-minute hearing and driving 3 hours home, and what that means to your life, you know, getting on the road at 6 a.m. to be somewhere for a 9 a.m. hearing in the dead of winter when it's dark outside. And I just remember that's not fun. That's not fun for the lawyer. It costs a lot of money to the client. A lot of clients only pay half travel time, which is bad for the lawyer. So I like the idea of Zoom hearings. I think it's more efficient for the attorneys and for the parties. So I would be in favor of continuing that as we go forward. Although we haven't had any formal discussion around here about that, but I think it's a good thing. We're set up to be, we're on the record. It's preserved just like anything else, and it works just fine for most types of hearings.
I think we are all open for lawyers contacting our office directly and say, hey, can we schedule a Zoom hearing? I've been in contact with the other side and we're in agreement. We're going to need 20 minutes or we're going to need an hour and a half. Am I right, guys?
Yes.
Absolutely.
Well, and I think if both of the parties, like Judge Van Meter said, are agreeing and they're fine to do it with Zoom, when they notice it or ask, they could just make it an agreement that the parties are agreeing to a Zoom. And unless we feel compelled to have it in the courtroom, we would just do it by Zoom. Or at least I would do that.
Yeah, agreed.
Yeah.
The next question is, how do we ensure the public can get access to hearings if they are not parties?
Is that a contemporaneously or afterwards?
I guess both.
Well, Judge Bunnell, why don't you answer that?
Yeah.
All right. Well, I can tell you we've been doing that. So with Marcy's Law, we've been making sure that victims' families have had access, even when the courthouse was not available for them to attend. We were contacting the Commonwealth. The Commonwealth would contact us and say, hey, these folks would like to observe. Ms. Carter then would be invited to the Zoom conference, and we were making the multi-purpose room available where we were putting the Zoom conference up on the big screen and they could observe. That has also been happening for our media. Anybody that wants to have access that maybe is not exactly allowed into the courtroom because they're not a party or they're not the plus one, so to speak. So we're keeping our numbers down. But if they contact us, we're making arrangements so that they can log in by Zoom. After the fact, then everything's being recorded, and so anybody can order a copy of a hearing the way they previously would.
Okay. Will preference be given to in-custody defendants once we begin holding trials again?
That we've already answered that one. Yeah.
Yes. I think the answer was yes.
Although I don't envision that if you have a civil trial, you should consider your civil trial to be in jeopardy and you're likely going to be bumped. I would never bump anybody's trial without having a conversation with them and discussing it before that, because we understand that you've lined up a lot of things to make that happen. You've lined up witnesses, you've subpoenaed them, you've lined up your experts, people have perhaps booked flights, you're making big plans about these things. So if you have something coming up that you're particularly concerned about because you're very invested in a civil case that's set for trial, I think you should absolutely feel free to call the judge's office and maybe set up a Zoom call with everybody involved to talk about that. Because it's helpful to us too to know if there's something like that on the docket that it's important for it to go, then we can look for other options if we have a criminal case that really also needs to be set around that time frame. So the answer is I think we have to give priority to in-custody criminal defendants, but I really hope that we can do that without disrupting our civil trials that are already set. Because we all know what that disruption means for you and want to avoid it if we can.
What if one party wants to continue trial due to concerns posed by COVID-19 and related restrictions, and the other side does not? How will you resolve this issue?
Hold a hearing.
Exactly right. Yeah.
I don't know. I don't know what the issues are.
It'd be a case-by-case basis, Judge Travis, wouldn't it? I mean,
I agree. Don't
Yeah.
know.
I mean, obviously, guys, we're going to rely on the lawyers to be truthful with us. I mean, if somebody says, that I have a vulnerable client or I'm an at-risk person myself and I'm not going anywhere and I don't want to be in a courtroom with a bunch of people yet, you know, we hope you're being honest, then we better not be finding you at the Walmart on Saturday, right? So I think just we're going to have a healthy dialogue, and like you said, that dialogue probably will be at a hearing, and we hopefully can reach a resolution that'll be acceptable to everybody. And if not, then we got to make the decision.
Yeah, and we could do the hearing by Zoom if health issue, not by in person, but yeah.
Yeah.
And so far, I feel like everyone has been very cooperative with all that is going on. So this has come up. I've had several calls with several people who have trials scheduled in August, and we've scheduled times for all the lawyers to talk. And you know, as we talk through it, everybody has seemed to come to a consensus about what makes sense for that case, whether it's because the attorneys have a concern or a restriction, or because of a concern for the client and the magnitude of what is at stake, and not wanting to do it that first week, you know, before we really know how things are going to shake out, or whatever the case may be. There hasn't been I haven't seen big disagreements there. Everybody seems to be trying to work together to get through this time.
I agree. I think that my impression, and I've been very impressed with how the members of the Fayette County Bar have worked together to keep things moving. And I think one of the positives, if there is a positive that has come out of this, is the bar, everyone seems to be talking to each other more. They have more time to talk. They have more time to relate to each other. And I think that's been a positive, because I've had no problems with the attorneys all trying to work together to make this as easy as possible.
I don't have any more open questions.
Well, let me.
I'll ask everyone kind of a fun question. Where's the strangest place you've had an attorney while zooming from? I've had zooming from vehicles parked, because I did ask. Zooming from garage with all the tools and stuff laid out behind.
Yeah.
I've had zooming from cars. I've had zooming from a pool.
Oh, wait a minute, that was Judge Van Meter.
No, that wasn't. Yeah, well, I wasn't thinking of her, though. I've had a criminal defense lawyer from his pool sitting by his pool.
Sorry, Judge. Sorry.
So, yeah. The best was how many have had lawyers who are willing to stand up and show that they had the coat and tie on, but they had shorts on from the waist down rather than dress pants.
Well, I've seen several lawyers posted on social media, you know, getting ready for court, and here's their tie and their shorts. So kind of calling themselves out. We wouldn't know otherwise.
I had one lawyer participate from his beach house in Florida, which made me quite envious.
Yes.
And then I had one other lawyer who was obviously at home taking care of the kids and the family with the dog barking in the background. Fortunately, I haven't heard any toilets flushing yet. But
that's good.
It's probably going to be happening sooner or later. So that's my input on that one.
Well, we're waiting on other questions. I'm sorry. Go ahead.
That's another reason why Zoom is so great, because, you know, your lawyer who is on vacation, everybody's plans are so up in the air right now, and you got to just sort of take it when you can get it. And if you've got just a little pretrial conference that's holding you up from going somewhere, how nice that you can be traveling and on the road and still handle that remotely. It's just gives so much freedom of schedule to the lawyer. Now, us not so much, because we're sort of stuck here to be on the record, but that's okay.
Yeah. Just
while we're waiting on other questions, I just wanted to talk a little bit about what's going on in terms of the country and our focus on racism. And as members of the court and members of the bar, we can't ignore issues that also exist within the judiciary and our court system. So I did want to mention that there's been an effort to try to look at our legal system and to try to get a good read on just where are we in terms of racial attitudes in the court system. And we were finally successful last year in getting a professional survey done of the attorneys and the judges around the state with the help of a professional from the University of Kentucky to survey and to see what the attitudes are about not only race, but also gender and LGBTQ in our court system. And those results were compiled. And actually, before this virus, we were getting ready to do a CLE program here in Fayette County in March to have Dr. Otis, who was the one who helped us put together the survey, and a panel of attorneys to talk about the results and what it means. But we're now looking to do it in August, on August the 20th. It's going to be, if we are allowed to do it, it'll be at the multipurpose room at 12, August the 20th, and it'll be to talk about the results. And it is no surprise that even though overwhelmingly people feel that we're doing pretty good when it comes to race, gender, and LGBTQ issues throughout the state and our legal system, a significant number of attorneys and judges think that we still have problems. And so it's good that we finally have data for Kentucky and our legal system, whereas some states have done this 20 and 25 years ago. We're now getting to the point we have professional survey done, and we hope that this will start our conversation in the legal system as to how we can improve matters involving race, especially, which is the most pronounced issue, but also gender and LGBTQ issues. So I hope we have good participation from the bar on this CLE program, which we hope right now to do August the 20th at 12 o'clock in a multipurpose room.
Thank you.
We have some questions. Have there been any thoughts / discussions about maybe allowing some civil motions, parentheses, motions to withdraw, default judgments as examples, close parentheses, to be either done at convenience of the court, put in the notice that if after 10 days no response is filed, the court will grant motion to reduce how many of us are either on Zoom or in the courtroom for now?
So I'll take part of that. So I saw that pending over there. Local Rule 20. So I love rules, and we have these local rules that are really great. And when I was a new lawyer in the Fayette Circuit Court, I won a motion. Of course, I knew you didn't tender your order with your motion. You just filed your motion. And then if you won, you prepared the order. So I had won the motion, and I prepared the order, and I submitted it to the judge, and the judge called me and said, your order does not comply with our local rules. There's an attestation that was required, and I'll talk about that, what that rule is, and you need to resubmit it. And I was truly a brand new lawyer, and I knew about the civil rules, but I didn't know that every local jurisdiction had their own set of separate rules. So that judge was Larry Van Meter, and I always tease him about that.
Yeah.
He has no memory of this, but I remember because I was so torn up that I had violated this rule and got called on it. But anyway, Rule 20 of the Fayette Circuit Court relates to default judgments. And it says that the party seeking default shall file a written motion accompanied by a certificate that no paper has been served upon the attorney by the party in default and an affidavit stating whether the party in default is in the military. If the party in default has failed to appear in the action, the motion need not appear on the motion docket, and no notice thereof need be given to the party against whom judgment by default is sought. So default judgments, so long as no answer, or sometimes there's one of those kind of, there's something that's filed, but it's not really an answer, but it's something. If that's the case, if there's been an appearance, then you do have to schedule it for a hearing. You do have to give notice. But under the local rule, if there's not been an appearance, then you don't have to set it for a hearing, and you don't even have to give notice. You just file your motion and we rule on those. So a lot of people file motions for default where there's been no appearance and they set them on the docket, and that's fine. And we have a hearing and we deal with those at motion hour, but you actually don't have to under the local rule. Motions to withdraw, my hesitation on that would be I would want to make sure, does the client know that you're moving to withdraw? Are there any deadlines coming up in the case that are going to negatively impact that client? So that's I would hesitate to ever file a motion to withdraw without having a hearing and getting some answers to those basic questions, just to make sure the client is not adversely impacted by that if we have some deadlines coming right up. And then the other thing, while we're on the subject of the local rules, I was one of those people during the COVID-19 that decided that I was going to start e-filing orders in civil cases. I'm starting with civil cases. And so it's been really easy, like Judge Bunnell said it would be. And I've enjoyed doing that because I know they get out quicker to the lawyers and it's good for everybody. But local rule 19 has to do with orders. When a ruling is made and you tender that order conforming with the judgment, there is a specific attestation that the local rule says you should include. And that is either that all the lawyers agree that it conforms to the ruling, or there was no opposition at motion hour, or the party that you sent it to had it for 3 days and they refused to attest. And the reason that's really helpful is, you know, we will have maybe 100 cases on a Friday. And so while I've read everything and I've got notes and I know exactly what it was when we're in the moment, if that order is tendered 2 weeks later, or even sometimes 1 week later, you know, I don't really remember, is this right? I think that's right, but is it not right? And so it's very helpful to have that, to know that it did come on for a hearing and the lawyers agree this is in conformity with the ruling. Because otherwise, if that's just in the queue, if it just says granted or denied, then, you know, I have to look the case up. When was it heard? Go back and look at my notes, make sure it's correct. And it adds a lot of steps and it delays getting that order entered.
I love the intro sentence that says this matter having come before the court on May 27th.
Yes.
So helpful.
You're reading my mind up there.
That's a beautiful thing.
Truly, sometimes orders are tendered 4 months after the hearing. I mean, it's really helpful to have that date in there.
And guys, if you see that we haven't signed something, it hasn't been processed, please call our offices. I mean, you're not going to offend us and go, you know, that one that we submitted back in January. Do you know that if the judge is still thinking about it? It's like, no, we're not thinking about it. It's somewhere, but you know, we need some help finding it. So please let us know. We'll go looking for it.
Next question. When it comes to evidentiary hearings, especially criminal trials, how do the judges feel about the use of masks by witnesses? Following up on Judge Scorsoni's comments about nonverbal facial expression being important, does it raise confrontation clause issues to allow a witness to testify behind a mask in criminal trials?
That's a good one for you, Judge Scorsoni.
Yeah.
Well, I personally, in a criminal case, I would not allow a witness to testify through a mask. We would have to make some arrangements for appropriate distancing. In some courtrooms, it's no problem. In some, there may be a problem, but I cannot imagine legit confrontation with a mask on a witness. I'm sorry, I don't think that'll fly in my courtroom.
Yeah, I agree.
I think you also have to think about that with voir dire. I was talking with some lawyers this morning about voir dire with a mask. So much of that is looking out at your potential jury pool and watching their facial expressions and how they react. And, you know, lots of times if you can pick up on a small cue, they want to respond, but they need a little push to. And so if you're covered up, I think that's another reason why a lot of lawyers are hesitant to move forward with their trial if we're going to be in that situation.
All right. I don't have any other questions for the panel at this time, unless somebody wants to type one in really quickly. I have also a list of questions here, but I feel like that you've really kind of covered most of the questions that were sent before. For jury trials. August, yep. Oh, in the season of summer associates, any concern with summer associates attending via Zoom, even if not in the same place as attorney?
I think it's fine. I do that with our externs through UK. They get on, they just don't put their picture up. So I wouldn't have a problem in my division having summer associates just get on to watch. Good learning experience.
I agree. I think it's fine. Jennifer Kaufman has a big group of externs who are Zooming with us this summer, and they keep their video. They don't turn on the video, and they keep themselves on mute. That way we see them in the list of participants, but they don't clutter the screen, you know, with another person. Because there is something, especially in motion hour, when you have so many squares, trying to orient yourself as to who's talking and where to go visually, where to look. So if you're the lawyer, it's helpful to say before you know, I'm Lucy Van Meter, I'm representing so-and-so, and this is a motion for X. That helps us orient and find you who's talking. So I think it's fine for summer associates to Zoom in. I'm sending my list of hearings to the externs and just letting them pick and choose. It's nice to know if they are going to Zoom in. Because we will see that name, and it's always nice to know who it is. So if you see a name that's a law clerk or that's an extern, just to sort of know who's on your call. But I think it's a great opportunity for law students. It really opens up their access because they don't have to physically come down here, and they can Zoom from anywhere. From the pool, because there's no video on them.
Well, on top of that, most of our Zoom proceedings are in the public domain, so to speak. They're not confidential. It's like being in the courtroom as well. So I've never thought of it being an issue or problem.
All right, let me ask our judges. Does anybody have any kind of closing comments y'all would like to say? Judge Thomas? I'm sorry, Judge Travis? Judge Thomas, you know, we're personal.
No, other than, yeah, don't hesitate to contact the judge's secretary if you have a matter you know that's going to be maybe require more than just a few minutes of a hearing. And we'll be happy to accommodate you with a special hearing date and time, no problem. In fact, the more that we can get off the regular Friday dockets, usually the better. And that's going to be particularly true the next couple of months, since we're not going to be having jury trials. We do have a little bit more freed up time on our schedules to accommodate that. So aside from that, no, my compliments to the local Bar Association for this program, and to all the practitioners before the court. Everyone has done a fabulous job during these extraordinary circumstances.
Thank you. Judge Corsoni?
Nope, nothing. Thank you.
Judge Goodman?
Same as Judge Travis. I think everybody's doing a great job. Thank you. And don't hesitate to call the office if you've got a concern or you want to set up a hearing. We're here. We've never left. And so, and also thank you for participating today.
Judge Van Meter?
Just want to thank Dana Arnold and our bar for setting this up today, and also for being the conduit to help us get information out to the bar. Whenever we have something to communicate you know, you're our go-to. Let's get that to Dana because we know you can push it out to everybody, and that's so helpful to us. So thank you for that.
Oh, thank you.
Ms. Carter, you got anything you'd like to add?
No, just as that we're here, and if you need anything, and we'll be summoning jurors and figure out how we're going to make this work. So any ideas are all welcome.
Absolutely. And guys, you know, we say this all the time. We don't always know what's going on in our fellow judges' divisions. And so if you see something that they're doing that's working, that maybe one of us hasn't tried, let us know. And so we're constantly trying to make this better. We all work together. The Commonwealth Attorney's Office, the Public Defender's Office, the Civil Bar. We have spent a tremendous amount of time scheduling and rescheduling, and we will continue to do so. And we appreciate your understanding, and we just say thank you all. So thanks.
Thank you. Thanks everyone for attending, and thank you so much for presenting. I think it's so helpful. I will convert this and post it somewhere, hopefully. So if somebody needs to watch it later, you will be able to. So thanks again, guys.
All right.
Anything I can do, let me know.
Right.
All right, thanks.
Bye.